Okay, it is exactly 7 o'clock Central Standard Time. Today is Monday, May 30th, 2022, Memorial Day. Interestingly, the original Memorial Day was May 30th, and that usually it's the last Monday in the month of May, and that's what this is. So today is Memorial Day. I know many of you are enjoying your holiday, but I still had to come in and do the lecture. So I'm going to provide details concerning the assignments that we are doing. Okay. And so I'm going to go ahead and share my screen and we'll go over the assignments. Okay, there's my screen shared with you. All right, so we have messages here. Your grade book, which tells you the assignments for this week. We're in week number four. So we're going to deal with the Fifth Amendment limitations, the right to remain silent as a discussion, and then the key phrase that I will be giving you today. Okay. Let's take a look at the calendar. Turn to the month. You'll see that this is the last lecture in this month. This is where we are, the 30th, week 4. Initial post due tomorrow night. Your reply post is due Saturday. And then let's go over to let's go over and look at the calendar. You can see that already. Saturday is the 4th, so we'll be already in June. And then your written assignment and live classroom phrase will be due on the 5th. Notice we have 2 more weeks coming up after that. Course ends on the 17th, not the 18th, not the 19th, but it ends on the 17th. All written assignments must be in unless you have been granted a incomplete, and the one who has the power to do that is not your dean, not your advisor, but me. And you need to be reaching out to me to let me know. And I take time to determine, first of all, how much work have you done already? Secondly, I look at and see what kind of circumstances that are there, and if there are extenuating circumstances that I deem, then I will grant it. So it's very, very, very important. Remember, assignments from weeks 1, 2, and 3 must be in before the end of this week coming up, before the end of this week. So by the 5th. So 1, 2, or 3. Now, I didn't say you would get points, all the points, because technically week 1 is, you're out of it. Week 2, you're out of it, but week 3 was just due on yesterday. So you have 7 days after that. So, but let's see what we can do. I haven't heard from anybody about extenuating circumstances. I do know that if you submitted an assignment and I told you that the format was not proper, then you can resubmit the assignment all the way up to the last day of class without any penalty. So be aware of that. But you got to submit it in the proper format. Okay, and I always tell you every week what the format is. The format for week 1 was PowerPoint. The format for week 2 was Word document. The format for week 3 is Word document, and I'm going to talk about week 4 as well. So let's look at the announcements. So week 4 announcement. So we're going to deal with the Fifth Amendment and government authority. And you are to read chapters 4 and 10 of the textbook. I sent you the corresponding PowerPoints to help you prepare your papers. We're going to talk about double jeopardy and these other issues involving Fifth Amendment and due process. All right. So the right to remain silent. So this week, um, the discussion assignment is right to remain silent. Again, I'll repeat, it is due initial post tomorrow night, which is Tuesday, and on Saturday, your reply post is due. All right. Finally, be sure to complete the written assignment, Fifth Amendment limitations. And then we'll talk about the details on that in just a few minutes. And then your key phrase. Remember, I want you to continue to be strong and finish strong. If you make a mistake, get up, keep moving. You'll learn that my motto is adversity is the springboard to success. Pay close attention to what I say in the lecture, on the lesson tab, and the rubrics. Very, very, very important. Very important. All right. So that's the announcement for week 4. Let's get into the module itself, Fifth Amendment and government authority. So let's start out with the first thing that I usually talk about content-wise is your written assignment. Now, you're going to discuss the limitations of the Fifth Amendment as applies to this scenario. Okay, you're going to develop not a 1-page, but a 2-page paper at the minimum, double spaced, APA, citations in the body, and references at the end. If you cite a case, I require that you submit the official full court case citation. It's generally available in the module, and I'll mention it, and then you could just Google the case name, and it will lead you. And these are Supreme Court cases, so it'll have a number, and then it'll say U.S., then it'll have another number, and in parentheses, it'll have the year. That's the way you need to do it at least once, with the name of the case before that. So discuss when the right to remain silent applies in criminal cases. We'll talk about that. Support your cases with appropriate case law. Did you hear me? Case law. Case law. If you listen to my lecture, you will know some appropriate case law, at least one for sure. Explain how you would handle demand by Jim's mother. There's also some case law that we will be discussing that fits within that. Describe how you would proceed, including how to properly handle Miranda when you continue to question Jim after arrest. Discuss how ensuring Jim's rights are protected is essential to procedural due process. Cite credible sources in APA format, including a cover page and a reference page. Remember, I said double spaced. Use professional language, correct spelling, grammar, and punctuations. I run all of your papers through Grammarly. The process that you must submit your papers in order for me to run it through Grammarly is as a Word document. There is no other way. If you submit a PDF, you're going to get a 0. And I'll remind you to resubmit it. I say that every week. Every week. If you have issues, you need to reach out to tech support, get that corrected. You might have some problems with your computer. You might have to go on to another computer. Blackboard itself does allow Word documents. Students submit all the time Word documents, and it's very important for you to do so, unless we state another system, like the first week's assignment was a PowerPoint. That was no problem. All right? But it's very important. Very important. All right. I'm going to show you the rubric. Remember, the way to get your grade is listen to what I say in the lecture, read the module, and then finally look at the rubric. Notice if you don't have citations and you don't have cases, you're going to end up over here because it says missing appropriate details from cases, incomplete or no appropriate case law. Same thing here. No credible sources are provided and or references. The point of the matter is that you must cite cases. And it must be a minimum of 2 pages. Otherwise, you're going to end up over here. So what I focus on with all of my students is to go through each section, the right to remain silent, provide an outstanding discussion of when the right to remain silent applies. And I'll talk about that with details from appropriate case law to support your ideas. Do you hear me? And when you cite your cases, I already told you how you have to cite them. Jim's mother's demand. Outstanding explanation of how you'd handle Jim's mother's demand with case law to support it. Miranda and protecting rights. Outstanding description of how you would proceed, including how to properly handle Miranda. And you should properly cite the process and the case. You will have already cited it earlier, but let me just say this to you. Please do not cite Oyez or fine law. Your reference page should also reflect the full Supreme Court case citation. Credible sources with no errors, and then a minimum of 2 pages in a Word document. Okay. So that's the written assignment. Let's get to the discussion. Right to remain silent. And we will be talking about that. Of course, you know where that phrase came from. If you don't, you'll know by the end of this lecture. You'll apply the right to remain silent to a scenario. This is the scenario. So for your initial post, discuss the strategy you would use to set up the non-custodial interview. What would you do to ensure that a non-custodial interview exists? When might the interview transition from non-custodial to custodial? I'll be discussing that tonight. Discuss when the right to remain silent would and would not apply. Support your strategy with constitutional law cases. In your reply to another student, okay? Again, the initial post is due tomorrow night and your reply post is due Saturday. Your live classroom submission, this is where you're going to have the key phrase for your points. Then this is where your link will be for the recording, because this will be taken out. And then I'll email you the link as well. I do that every week. And then we're going to discuss the topics of double jeopardy, a few cases, the right to remain silent, just brief court case review, procedural due process, and then just show you how you can do a knowledge check for yourself. All right. So now let's start out by talking about double jeopardy. Now, if you will take a look at the Constitution of the United States, and you look at the Sixth Amendment, it says, in all criminal prosecutions, the accused shall be enjoy the right to a speedy and public trial, except in juvenile cases, by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have previously ascertained by law and to be informed of the nature and cause of the accusation, to be able to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his behavior, and have the assistance of counsel. Very, 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 very important. Okay? So that's the right to a fair trial. Now, the amendment that precedes that directly addresses the direct point that I'm making about double jeopardy. It says, no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger. Now, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. Okay, that's the double jeopardy clause. And we'll talk about that in just a moment. Nor shall you be compelled to testify against yourself, nor be deprived of life, liberty, or property without due process of law. And then nor shall private property be taken without just compensation. Now, so the Fifth Amendment is the amendment which directly applies to the due process clause. The double jeopardy clause. Okay? And you cannot try a person for the same offense twice. Now, let me explain to you, first of all, number one, you're going to discover that if an individual is tried in a state court and then in a federal court, those are two different standards, not two different standards, but the double jeopardy does not apply because there are two different venues. And oftentimes in the federal court, there are additional charges that are added that were not involved in the state case. So you can theoretically be convicted in the state court and then in the federal court. All right. So the Fifth Amendment prohibits double jeopardy, and I already read you what it says. And so let's look at these two instances right here of a young man or a person. Double jeopardy clause applies to juveniles who are tried for criminal offense as a juvenile and then tried again for the same offense as an adult. Now, this is an application of double jeopardy that came about in Breed versus Jones, a 1975 case. And the 17-year-old, his name was Gary Jones, was determined to be delinquent, charged with robbery. The juvenile court then concluded that Jones was not fit for post-adjudication and waived him to the adult court. Jones objected to the waiver, in which the California State Court upheld the decision, and Jones appealed to the United States Supreme Court and argued that it was double jeopardy for him to be adjudicated in juvenile court and tried again in adult court. The Supreme Court unanimously, that's a 9-0. You don't run across those very often. That means it's very clear law. Once a juvenile is adjudged a delinquent, they cannot be waived and tried for the same offense in adult court. The prosecution cannot have two bites of the apple. So it's very important for you to understand that. As it says, double jeopardy is a fundamental right, just like freedom of speech, freedom of religion, and unreasonable search and seizures of the Fourth Amendment. Double jeopardy applies to juveniles and adults who are accused of criminal wrongdoing. Okay, and so we'll talk about the right to remain silent in just a few minutes. So double jeopardy is very, very, very important. There was, and by the way, if you want to cite Reed versus Jones, there it is. See the appropriate citation right there. That's the case. All right. Now, let me explain something to you. And let's see if this video is working. It was working before. Let's see. There it is. So it explains double jeopardy. So you can look at the video and it gives the meaning of what it is and explains it pretty much what I said. So you want to take a look at that. You can't hear it, but so I'm not, so you need to listen to it yourself because I have my headset on. But I already explained it to you. But this video, in a musical way, explains double jeopardy. There was a movie that was done, and I always refer to this in my lectures when we get to this. It was called Double Jeopardy. Ashley Judd, Tommy Lee Jones were in the movie. And this was a case where a woman was charged with killing her husband. And she was tried and sent to jail and served her time. She would find out while she was in jail that in fact that the husband was actually alive and not dead. And when she got out, she was determined because she found out that he married her best friend. It was a whole setup to fake his death. They received the insurance money and all of that. He didn't, of course, but it was received. The bottom line is this, is that she began to pursue him and found him with a new identity. He had moved to another jurisdiction from where the offense had happened, which was California, no, which was um, New Orleans, Louisiana. And she tracked him down, uh, confronted him, and then he tried to kill her. Well, her parole officer was looking to catch up with her because he found out what was going on. Well, the movie ended with her actually shooting him and killing him. And because of the fact that she was never divorced, technically the property belonged to her, but she said she didn't want any parts of it. But here's the other point. They announced that because you served jeopardy for a crime, we cannot try you again for the same crime because he is dead this time. So that's an illustration of Double Jeopardy. If you get a chance to look at it, it's a very interesting movie. And the name is Double Jeopardy. All right. Okay. Let's talk about, just for a moment here, defining double jeopardy cases. You can go over and look at that yourself, but I'm just going to show it to you. Palco versus Connecticut. If you click on this, it tells you about the case, and it talks about the rights under the process not to be charged twice. Palco appealed to the U.S. Supreme Court, and in an 8-1 decision, that was a 37 case, rejected his double jeopardy claim because double jeopardy was not a fundamental right and did not apply to the states. However, look at what happens. In Benton, 1969, the court applied the double jeopardy clause and agreed with Benton, since Benton had already been tried and found not guilty, he could not be tried on that charge. Therefore, the Fifth Amendment double jeopardy applies to state cases. So remember, in Palco, it hadn't applied to the states yet. But in Benton, the Supreme Court says, yeah, it does apply, and it makes sense. And so that's what happened. All right. So that's a little bit of clarity for you. All right. So let's talk about the right to remain silent. Every one of you in this class understands that the right to remain silent originated from the landmark case of Miranda versus Arizona, a 1966 case of which I'll make sure that you have the citation because it's very important. I am very familiar with the case because My law professor was the author, along with a guy named John Reed. My professor's name was Fred Enbow, and they had a book that was written called Interrogation Techniques. And the police used these techniques. Uh, and the Supreme Court said in this case that those techniques violated the Fifth Amendment right of individuals. And thus, they carved out the rights that we are familiar with now. And my professor was very upset. He told us this in 1975 in our class, remember, many years after the Supreme Court case, that he would write an amicus brief or friend of the court brief to the Supreme Court every time to try to overturn Miranda. He died, and it's still the law of the land. And so the Miranda warnings are given to individuals during an interview. Now, one of the things that you should be aware is that Miranda warnings don't kick in as a requirement until the interview turns custodial. In other words, you don't have to tell the person that they're under arrest. If a person is not free to go, and it's clear that they're not free to go, then before you question them, you must provide the Miranda warnings. Otherwise, anything that you elicit from them in the terms of the statements will not be admitted in the court of law. And it will be taken away because, remember, we talked about the fruit of the poisonous tree. We talked about that because you can't use that because it's not constitutional to you take those statements and use them. So it says you must read these rights. And now police officers are trained, as it was when I was a police officer, even in '89, to read from a pre-printed card the Miranda warnings. And during the interview, it says you have the right. So anyway, you read the rights during the interview. During the interview, person makes incriminating statements and asks you, do I have the right to remain silent? What is your response? You have obtained enough information from the suspect to establish probable cause he is no longer free to go. So Miranda rights apply when the person is not free to go. The suspect mother, here right here, arrives at the station lobby and demands the police recognize her son's rights to remain silent. Remember that from earlier. Your response to her. You're going to get the answer to these questions right now, all of those right now. Okay, so you're familiar with this well-known application of the right to remain silent. And you know what they are. You have the right to remain silent. Anything that you say can and will be used against you. You have a right to an attorney. If you cannot afford one will be appointed to you. And do you understand these rights? And again, police now read it from a pre-printed card to protect themselves. Okay, these Supreme Court rights are so appropriate that because Miranda provided a written statement and was convicted at trial, the state court affirmed the conviction because he didn't request an attorney. But the Supreme Court said, oh, wait a minute, that's not true, and cited the advisement of Fifth Amendment rights were necessary. And thus came the Miranda rights. And the rights are more than just procedural. They are part of the Constitution. If you read Dickerson versus the United States, a 2000 case. Now, I already told you this. It says it applies only when the person is in custody. It says you don't have to use the words under arrest, but the test is determining if the person is free to go. If they're not free to go, then they are under arrest. Okay. Now, if the police arrest an individual but don't wish to question them, then you don't have to give the warnings. But generally, police officers do it anyway. And it makes sense because anything that does come out after you have them in custody can be used. All right. It says fictional law enforcement stories often depict police immediately reading warnings upon arrest. Well, immediate advisement is unnecessary unless the police wish to question. Um, and but in the current times that we're in now, when a person is in custody and they start to talk, you advise them then at that particular point that they do that. Okay? If a person is merely detained while law enforcement investigates a disturbance or to determine what happened, then the questioning may not necessarily be necessary. But once the person is placed under arrest for a crime and the police wish to question that individual, warnings are absolutely required. Okay? It must be in a language that they understand, and it's not just your language, it's the language of the individual who is going to be questioned. All right. So, dealing with the Miranda rights, you can assert it under, by the way, Miranda versus Arizona. There's the appropriate citation, 384 U.S. 436. Now, the Dickerson case, 530 U.S. 420, it's a 2000 case. Now, if a person is subject to interrogation and they want to remain silent, any questioning should stop immediately. You can't ask them, are you sure? That is not correct. However, a suspect who voluntarily comes to the station for questioning and is not under arrest cannot assert the right to silence. And that's the Salinas versus Texas case. In non-custodial cases, the silence may also be induced as substantive evidence. When a suspect invokes the right to remain silent, it must be clearly expressed, as I said that earlier. Merely remaining silent is not an invocation of the rights. That's the Burgess-Thompson's case. And I said this earlier, written memorandum forms are used to demonstrate person understood the rights. A lot of times now, there's video now. Now, this last statement is applicable to what I told you earlier about the mother. The right to silence is a personal right and cannot be asserted on an arrested person's behalf. Okay, not the lawyer, not the parents, or any of those things. The individual himself. Now, in juvenile cases, it might be a little different, but I'm talking about in cases where the person is an adult. Excuse me. When the right to silence is expressed and questioning stops, you can't reapproach that individual and try again. But if later the suspect approaches police or asks for the police and say, I want to talk now, then you have to reinstate the warnings. And if you don't, it's going to end up being tossed out. Edwards versus Arizona. Again, the citations are under as references. So the right to remain silent, along with the right to an attorney, must be provided to suspects who are in custody for a criminal offense and subjected to interrogation. Failing to honor with a clear and unambiguous expression can result in evidence being subjected to the exclusionary rule, which we talked about last week, and the fruit of the poisonous tree. So it's an important aspect, right? All right, so let's get to the next section. Take a look at the court case review. I've already told you some cases. So we began. The right to remain silent case. Choose the case which best selects your answer. Which case established the right to remain silent? I already told you that, right? Yes. Miranda case. Remember? Which case established that an individual cannot assert the right to silence when being voluntarily questioned? Salinas talked about that. Which established that merely remaining silent is not an invocation. Talked about that. Which case established the right to remain silent is a personal right. That's it. See if you got it. Okay, here it is. People versus Houston. Very important that you get that. That's the one that applies to the mother. Which case established if the suspect reinitiates contact after requesting the police, can they interview them? Which one is it? Edwards versus Arizona. Okay. And then that's it. So this is just a summary of the cases that we have covered. And then you have the citations. Remember, you can use that information to help you with your written assignment. So let's talk about the final area, and that's procedural due process. Okay, now in criminal court cases, the key thing is to make sure, number one, that individuals have a fair trial, and innocent people should not be prosecuted. That's the goal of the system. And so because there are certain due process rights that are involved in criminal court cases that we discussed earlier before, let's expand on the due process and how the Constitution and the courts have shaped it. So the Fifth Amendment, where it states that no person shall be deprived of life, liberty without or property without due process of law, this is called the Due Process Clause in there. And the 14th Amendment applies to the states. All right. So that means that a defendant, when they are charged with a crime, have the right to provide a defense, and should have fairness given to them in the legal procedures. And the constitutional framers didn't specify what procedural due process is, but it's been carved out by the courts. All right. And so we began to look at cases way back a long time ago. Murray's Lessee versus Hoboken Land Improvement. And you cannot take property or deny a person of life, liberty, or property without due process of law. Okay. And you have a person who is charged, or a person who charges the plaintiff. In the state court cases, criminal, it's the people. Then you have a defendant, then you have a judge. Defendant is notified of the charges and provided an opportunity to answer those allegations. I talked about that. And a trial is something that they have. Now, be aware that probably 90% of the cases that come before the court end up being settled by plea bargaining. Okay. So one of the first steps that takes place once a person is charged is what we call the discovery or disclosure process. In that process, the prosecution must turn over any evidence that they have in their possession to substantiate the claims against the defendant. And the defense can have a chance to review that information. When in court, and before, the defense has a right to question the witnesses that the prosecution has. It says in the ICC versus Louisiana, Louisville case, it says all persons must be apprised of the evidence submitted and must be given the opportunity to cross-examine witnesses, inspect documents, and offer evidence. In other words, prepare a defense. Okay, so in each of the states, the pretty much these steps that I'm about to cover, starting with a hearing, where there's an unbiased tribunal, and that could be the court, the magistrate, or the judge. That's when you come in for arraignment. The accuser must be provided with notice of the proposed action. That's usually in the form of an information or an indictment. An opportunity to present reasons why the proposed action is going forward. The defense is allowed to call witnesses and to, again, be aware of the evidence. And only on the evidence is a decision made, whether it's a judge or a jury trial. The defendant has a right to an attorney. That's the Sixth Amendment right. Gideon versus Wainwright established that. A court hearing record is made. There are transcripts that are taken that the defendant is entitled to. A written statement of the reasons for the decision, and a public attendance. So that's the way that the process works. But ultimately, most cases are not disposed of by trial. They're disposed of by plea bargaining. Okay, so it's procedural due process is absolutely essential to protect the rights. I guess I could sum it up by simply saying to you that the due process rights mean that you at least have an opportunity to be aware of the charges and a fair opportunity to respond or prepare a defense to the allegations made by the prosecution. That's kind of the summary of it. And there are various steps that you go through, such as a bench trial where the judge hears, or a jury trial, or you can at some point decide to plead guilty voluntarily and then enter into a plea, and then a sentence is given based on that as well. Okay. So that's basically it. All right. So you don't just get charged and go to jail or you go free. No, you're going to have a hearing to determine to what extent that will take place. All right. Here is a little practice thing for you, and I'm just going to show you how it works. Which amendment prohibits double jeopardy? Is it the 8th? Is it the 6th, the 5th, or the 4th? That's the answer. The 5th Amendment. The 4th Amendment is unreasonable search and seizures, as I said. The 6th is right to counsel and other trial rights. The 8th is cruel and unusual punishment. Which amendment provides for the right to remain silent? The 5th. Okay. Which elements must be present for the right to remain silent to apply? Okay, temporary detention for a crime, subject to a general on-scene questioning, arrest for an ordinance violation and subject to questioning, arrest for a crime, subject to identification questions, arrest for a crime, subjected to questioning elicited to obtain incriminating statements. How about this one? Yes, because remember, it has to do with the Fifth Amendment. The other three options don't include the elements of the Miranda formula that we discussed. Four, identify the common steps of due process. Hearing in front of a judge, right to a phone call, right to cross-examine witnesses. Notice of charges, impartial judge, right to determine the sentence, and cross-examine witnesses. That's wrong. Why? Anybody know what was wrong with it? Let's go back and ask again. It says notice of charges, impartial judge, right to determine the sentence. See, that's not true. That's not true. In hearing in front of a judge, the right to a phone call, and the right to cross-examine, all those are consistent with the procedural due process that we just talked about. Hearing in front of a judge, right to an attorney, the right to cross-examine. There is no right to a phone call. A lot of people don't know that, but that's not true. There is no room. So let's go back. I want to go back to that one because I don't like the way they did it. Let's go back. Okay, we'll go back. Double jeopardy, Fifth Amendment. Right to remain silent. What elements must be present for the right to remain silent? Temporary detention, arrest for a crime subject, okay, incriminating statement. That's it right there. Okay, and then let's look at this one. Identify common steps of due process. Notice of charges. Impartial tribunal. Right to determine charges and cross-examination of witnesses. Notice of charges, impartial judge, right to determine the sentence and cross-examination. Incorrect. So both of these are wrong. And you'll see why. Both incorrect. Because they don't give you a correct answer. There is no right to a phone call. So I don't like the way that they did that. All right. What is the main goal of procedural due process? To ensure the rights of the victims are protected, to ensure rights of complainants are protected, to ensure rights of the accused are protected, to ensure the rights of jurors. How about the accused? Yes. And then that's it. All right, so you can look at those. All right. Okay. Well, that's it for today. And I'm going to give you a phrase that's very important. And I want the whole thing. And you give me that phrase for your points. Right to remain silent. Right to remain silent. One last time. Right to remain silent. All right. So I'll see you next week. Hopefully you understand the assignments, understand what I expect. And if you have any questions, feel free to reach out to me. Time is moving fast. We don't have much time in this course, about a few more weeks. So good night and have a good week. Enjoy the rest of your Memorial Day. Good night.